You're pulled over. Lights flashing behind you, you indicate. You pull in. An officer walks up to your window, has a look around, and then says 4 words that make your stomach drop. Open your boot, please. And in the next 10 seconds, you're going to do one of 2 things. You're either going to handle this calmly, on the right side of the law, and be on your way in a few minutes, or you're going to make one of the 2 mistakes almost everyone makes in this exact moment, and turn a routine stop into a genuine problem. Because here's what nobody tells you. A huge number of people simply open the boot the second they're asked, no questions, no idea whether the officer even had the right to ask. And a smaller group swing the other way. They've half heard that police need a reason to search your car, so they fold their arms, refuse outright, and end up arrested for obstruction in a situation where the officer actually did have the power all along. Both of those people got it wrong. And by the end of this video, you're going to know exactly which situation you're in, the moment it happens to you. I'm Oliver Bennett, criminal defence solicitor here in England and Wales. And in 15 years of doing this work, the number of ordinary, law-abiding people I've spoken to, who got themselves into unnecessary trouble over a car boot, not because they were guilty of anything, but because they didn't know where the line sits, would genuinely surprise you. So let me be the one who tells you where it is. Picture a woman driving home from the supermarket. Call her Sarah. She's done nothing wrong. She gets flagged down at a routine checkpoint. An officer leans in and says, "Would you mind opening the boot for me?" In the first version of this story, Sarah's instinct is to seem cooperative, so she pops the boot immediately, steps back, and lets the officer rummage through everything. Her shopping, a bag from months ago she forgot was even in there, personal items she'd rather keep private, without ever once asking why, or whether the officer actually had a reason to look. She wasn't legally required to simply agree. She just didn't know that. In the second version, Sarah's heard somewhere that police need a warrant to search your car. So she says flatly, "No, you don't have the right. I'm not opening anything," crosses her arms, and refuses outright in a situation where the officer, it turns out, genuinely did have reasonable grounds. Now Sarah is being told she's under arrest for obstruction, and the boot gets searched anyway, except now she's also facing a night in custody. Same request. 2 completely opposite mistakes. This video exists so you're never either version of Sarah. Let's start with the rule that trips people up more than almost anything else, because 2 separate powers get blurred together constantly. Under Section 163 of the Road Traffic Act 1988, a police officer can stop your vehicle for essentially any reason, or no stated reason at all. That power is broad, and it's not really in dispute. But here's the part people miss. Being stopped is not the same as being searched. The power to pull you over does not, on its own, hand the officer a separate power to go through your boot. To actually search your vehicle, including the boot Ibisbal, without your consent, an officer needs a specific legal power. Most commonly, Section 1 of the Police and Criminal Evidence Act, 1984, PACE. And Section 1 has a real threshold attached to it. The officer must have reasonable grounds to suspect that they'll find stolen goods, an offensive weapon, drugs, or other prohibited items in the vehicle. Section 1 explicitly covers not just you personally, but any vehicle or anything which is in or on a vehicle, which absolutely includes the boot. So the default position is this. A routine traffic stop on its own, with nothing else going on, does not give an officer the automatic right to search your boot. There has to be an actual, specific, articulable reason, not a hunch, not just a routine check. A genuine, reasonable suspicion, tied to you and your vehicle specifically. That's the ground you're standing on. Most drivers have no idea they're standing on it. Now, just like with any rights conversation, that default has real exceptions carved into it, and getting this half right is just as important, because this is the half that keeps you out of trouble. Exception 1. Genuine reasonable suspicion under Section 1 PACE. If the officer has real specific grounds, maybe they can see something suspicious through the window. Maybe there's a smell they can reasonably tie to the vehicle. Maybe there's intelligence linking your car to a reported offence. Then the power is real, and it applies. This is not the moment to argue the law on the roadside. If the grounds are genuine, the search is happening, and physically preventing it is a separate offence in itself, obstructing a constable in the execution of their duty, under Section 89 of the Police Act, 1996, Exception 2. You consent. If you agree to the boot being opened, that's a separate, valid basis on its own, entirely apart from Section 1. This is exactly why it's worth pausing before automatically agreeing, because the moment you consent, you've effectively waived the need for the officer to justify their grounds at all. Exception 3. You've been arrested. If you're arrested, a search of the vehicle connected to that arrest can follow under separate powers, and different rules apply at that point. That's a different conversation for a different video. Today we're talking about the ordinary roadside stop before any arrest has happened. Outside of those three situations, an officer does not have a freestanding right to simply open your boot because they've stopped your car. Here's where you need your wits about you, because reasonable grounds is the exact phrase officers reach for when they want access and haven't got a cleaner way to get it. Simply being nervous during a stop is not, on its own, reasonable grounds. Having an untidy or full boot is not reasonable grounds. Driving a certain type of car, at a certain time of night, in a certain area, none of that, by itself, meets the legal threshold either. Personal factors and generalized hunches can never support reasonable suspicion under Pace Code A, the official guidance that governs how these powers must be used. So if an officer asks to search your boot, and you're genuinely unsure whether real grounds exist, you're entitled to test it calmly. Can I ask what the specific grounds for this search are? You're not being difficult. You're asking them to actually name the reason, out loud, before you decide how to respond. If there's a genuine answer, something specific, something tied to you or your car, you'll hear it, and at that point, you comply. And if the honest answer is vague, or there isn't a real answer at all, you've quietly shown them, without raising your voice, that you know this power has limits. Before an officer lays a hand on your vehicle under Section 1 PACE, they're required to tell you a specific set of things. Police remember this with the acronym GWSLI, Grounds for the Search Object. What they're actually looking for. Warrant card, if they're not in uniform. ID entity, their name station, they're based at entitlement. Your right to a written record of the search legal power being used. You are being detained for the purpose of the search. This matters enormously for you, because it means you get to hear, out loud, the exact power the officer claims to be relying on. A power that has to be named is a power that can be checked, on the day and afterwards, by a solicitor if needed. If you're standing there genuinely unsure whether you're required to comply, there's one sentence that does more work than anything else. Am I being detained for a search, and what power are you using? This single question forces clarity. If the officer names a real power and real grounds, you now know exactly where you stand, and the sensible move is to comply with the physical search while keeping your objection, if you have one, calm and verbal only. If they can't name a specific power, or the grounds sound thin, you can say clearly, I don't consent to this search, but I won't obstruct you. That sentence is doing two jobs at once. It makes clear, on the record, that you haven't voluntarily agreed, which matters if the search is later challenged. And it makes clear, you're not going to physically resist, which protects you from an obstruction charge, regardless of whether the search itself turns out to have been lawful. Here's the mistake that quietly causes the most trouble, and it's got nothing to do with whether you open the boot. It's volunteering. The moment the boot is open, whether because you consented or because genuine grounds existed, officers will often keep the conversation going. Where have you been tonight? What's all this for? Whose bag is this? You are almost never obliged to answer any of that. Opening your boot because a real power applies does not mean you've signed up to narrate your entire day. You're allowed to be completely calm, completely cooperative on the parts you're required to comply with, and quietly silent on everything else. A simple, polite line works well. I'd rather not get into that. That combination, comply with what's real, stay quiet on what isn't, is the entire game. Let's walk through exactly how this plays out. An officer stops you and asks to open your boot. Your first calm move is the pivot question. Can you tell me the specific grounds for wanting to search the boot? If they give you a genuine, specific answer, you comply, calmly, and you can add, if you want it on record. I'll open the boot, but I want to note I'd like a copy of the search record afterwards. If they can't give you a specific answer, or the answer is vague, just a routine check. We like to have a look sometimes. You're entitled to say, I don't consent to a search, but I'm not going to obstruct you if you insist on proceeding. You do not argue about whether the grounds genuinely meet the legal threshold while you're standing on the roadside. That fight, if it needs to happen, happens afterwards. With a solicitor, with the written search record, not with the officer at the roadside. And throughout all of this, 3 things matter more than anything else. Stay calm and polite, because raised voices and aggression are the one thing that can turn a borderline situation into a genuine offense. Give only what's actually required. Physical access if the power is real, nothing more. And never physically block or grab at an officer, even if you believe they've got it wrong, because that risk, obstruction, or worse, exists regardless of whether the underlying search was lawful. This is the principle I come back to again and again on this channel, because it's the difference between people who walk away clean and people who don't. If an officer insists on a search and you think they've got the grounds wrong, the roadside is not the place to win that argument. You comply with the physical process, you stay calm, you make sure you get that written search record, you note the officer's name, number, the time, and the location. And if it turns out the search genuinely wasn't lawful, no real grounds, go wisely not followed properly, that's when you take it further. A formal complaint to the force, and if it's serious, the Independent Office for Police Conduct, alongside proper advice from a solicitor. If a search really was unlawful, there can be real consequences for how any evidence found is treated. Under Section 78 of PACE, a court has the power to exclude evidence entirely if the way it was obtained would make it unfair to rely on it at trial. That's a powerful tool, but it's a tool for the courtroom, built afterwards from a calm, well-documented account of what actually happened. It is never a tool for the roadside. Let's bring it all together, because I want this to genuinely stick with you. Remember the default. A routine traffic stop under Section 163 of the Road Traffic Act does not, by itself, give an officer the right to search your boot. That requires a separate power, usually Section 1 PACE styles, and a genuine, specific, reasonable suspicion. Remember the exceptions. Real reasonable grounds, your own consent, or a search connected to a lawful arrest. Remember the pivot. Ask calmly what the specific grounds are and what power they're using. Remember go wisely. Officers are required to tell you the grounds, the object of the search, their identity, the legal power, and your right to a written record. And remember the golden rule that ties it all together. Comply with what's genuinely required, stay calm and largely silent on everything beyond that. And if you think it was wrong, challenge it properly afterwards, never on the roadside. Because here's the truth of it. In that moment, standing by your open boot, the officer is very often relying on exactly one thing: that you don't know where the line actually is. That you'll either hand over everything without a second thought, or refuse everything out of misplaced bravado, and that either way, you'll get it wrong. The single most powerful thing you can do is stand there calmly and show them, in one quiet sentence, that you know exactly where the line falls. That changes the entire encounter. I'm Oliver Bennett. Know your rights, because the people who know them are the ones who walk away clean. I'll see you in the next one. This video is for general information only, and does not constitute legal advice. Every situation is different. If you're dealing with a specific incident, speak to a qualified solicitor.